Pasha Paro, White and 7. Thank you for tuning. All right, give me a second here. Okay. Hope all is well with you guys this day. And we're gonna get into it. Another trip in the rabbit hole. Let's go. Okay, so many of you recall we were going over number 30, immunity of the United States from suit absent express consent. Excuse me. We actually went over United States versus testing in the last video. If you aren't familiar with that inside and out, and whether you are or not, just go ahead and watch it, because we took some turns in there that may be beneficial for you and add value in the future. So what I want to look at now is the next one, which is actually Reed. I'll say Reed versus United States, and that's from 1909. Okay, so let's take a look at that. Here is the Justia, and just so you have the little disclaimer, you already know Pasha is giving this little entertainment, comedic little thing on this big idea. Okay, so not an attorney. I don't do titles, and if you're looking for someone with a title, then go find them and be helped. Okay. There, you have their disclaimer, so they're good. Let's get into this here. Okay, so Reed versus United States, 211 U.S. 529, 1909. All right, argued December 11th and 14th of 1908, and decided January 4th, 1909 per their accounts. Okay, so it was an error to the District Court of the United States for the Southern District of New York. The syllabus is: suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. Kawananako versus Polyblank, 205 U.S. 349. And the statutory change in the ordinary business of the courts will not be held to extend that permission when the general policy as to such suits is maintained. Then it tells you a little bit about the act. The act of March 3rd, 1891 deals with general and not special jurisdiction, and nothing in subsections 5, 6, or 14 extended the right of review of judgments of the district court citing or sitting as a court of claims under Act of March 3rd, 1887. And a writ of error will not lie to review a judgment in favor of the government on a claim of less than $3,000. Courts must make or take notice of the limits of their jurisdiction. Courts must take notice of the limits of their jurisdiction. And the government should not consent to allow a suit against it to proceed if the court has not jurisdiction. And then there's some more details about it, etc., etc. Feel free to review that at your leisure. The part that we're going to cover today is this section here, and in particular, this first line is very, 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 very pronounced. I'm saying pronounced. Suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose for your entertainment purposes only. So let's look at some words here real quick. Let's take a look at some words. And what is a suit? So a suit is not the little, Armani, if that's still a thing, garment or fabric that one buttons up thinking they suave. You know what I'm saying? So in this application, the suit is actually the witnesses or followers of the plaintiff. They try to make a church out of everything. So, like I said, this is for your entertainment. Okay? I'm not an attorney. So the witnesses or followers of the plaintiff. Witnesses or followers of the plaintiff. So suits can be maintained against the sovereign power only by its permission. Only by its permission. See, think of a court like any other court, whether it's basketball, tennis, what have you, right? Some people, call on everyone to join the team, except for who can really help them especially when they're in trouble. Why? Because they wanted to be the LeBron. They wanted to be the star of the team. All right? They wanted to be the star of the team, taking all the attention, all the support, all the supporting characters now in that application are going to be of likely lower quality. Or they're going to volunteer to take a pay cut so they can be a part of the team, which still puts them into an inferior role. In other words, when you have a team and there's someone in the mindset of they have to be the not a star, not one of a star, not a team of stars, not a team with rising stars, but the star. What happens often is that the team can't afford, and don't be thinking about this just monetarily. Think about it as far as talent, depth. The team can't afford depth of talent on their roster. So when the star goes down, it has to call on his or her teammates. His or her teammates can't answer the call because they were never groomed to be called on. They were never groomed to be called on. The superstar took all that from them and gave them subordinate positions or roles, which they accepted, either via permission, which we're going to get into, or through acquiescence. The superstar at the time that he's in need or in trouble can't call on those who can help them because his or her pride won't allow the sharing of the spotlight, and him or her doesn't want to feel like they owe anybody something, which in a world so interwoven, even if that subject is paying you for a service, you have to admit to yourself there is a void that should be filled with gratitude for having the opportunity to even perform that service. So how can you ever feel like you don't need somebody? You don't owe somebody. This is why they call it paying it forward. How would it hurt you to know someone you cared about needed your help and never called you? But then when the story comes out, it's being told that they called everybody and nobody helped them, and you're left wondering why your phone never rang. This is why. This is why I give this entertainment and why I've always offered to help people. Even the ones out there running around right now saying I never did nothing for them. Many of you fall for these fairy tales because you forget the 48 laws of power, law number 7. Get others to do the work for you, but always take the credit. Always take the credit. Use their skill, time, and energy to further your ambitions while taking full credit. There's certain people you can call on for help because you'll never have to share the credit. However, if someone who has to have all the credit gets into a situation where they need something from someone who knows when credit is deserved, the person that wants to take all the credit can't put themselves in that situation because they know in some way, shape, or form they're dealing with another creditor, so to speak. Meaning, in that use of play of words, that they are actually going to take credit for their role too. Those that's been following the channel know, Pasha, I like to take credit for putting people in position. No, I'm not taking credit for every little step and every little thing that person did in that position to further themselves. But when you're dealing with the wrong mentality, they can't even express to the world. They can't give you credit. They can't give you the credit that you deserve, which makes them a debtor. So how does all this play into court? Not that I'm an attorney, but from a theatrical, entertainment, comedic sense. And that's what we're getting into today. So suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. And we established that a suit is actually the witnesses or followers of the plaintiff. This is why this is basically like you could translate this into how someone gets blackballed, right? Witnesses or followers of the plaintiff. So this person goes out there and creates their little fantasy fairy tale that they want to tell about this other person to their followers that they're keeping isolated and pinned into, you know, some sort of limited existence so they can maintain top of the pyramid status over these folk. Right? So they go and they testify. To their followers. Hold on, where? It's a good time to show you this real quick. Where's it at? Where I got it. I'm gonna jump ahead real quick for a moment. Cause see, this how a lot of y'all get shit fucked up. And y'all be thinking y'all know what y'all talking about. Or they be thinking they know what they talking about. They don't have no idea. They running their mouth about you. They feeling some type of way about you. See, because all this stuff is infinite. So I'm giving you examples in real life, so that because I'm not emotional. But for emotional people, I'm giving you the examples in real life for you to see the emotion you would have, so you can understand it in other applications of life. Okay. So you got this person that's gonna want to testify, basically, against your character to their followers, right? Their followers, the witnesses or followers of the plaintiff. Okay? So they go and they testify, they get the emotions stirred up and start to create this imagery and artwork of how they want you to be registered to other people. Suits can be maintained. Now look at this, because this is what we gotta look at. Scroll down here to this right here. We're gonna come back to this in a minute. A witness, remember what it said? A witness or the witnesses or followers of the plaintiff. So what is a witness? You kind of know what followers are. You on Facebook, you on Instagram, you on TikTok. You already got an idea what followers are. But what's a witness? So a witness is someone who may or may not have relevant information about whatever and we can take this out and put case may be. Right? Instead of saying lawsuit is about, to make it make sense for your whole life, whatever the case may be. A witness is someone who may or may not have relevant information about whatever the case may be. Okay, let's get back to this. So, suit, the witnesses, the people that know and don't know shit, and or just simply the ones following the leader of that side of the fence. All right. So what is maintain, right? Maintain is to maintain an action or suit is to commence or institute it. The term imports the existence of a cause of action. Suits can be maintained. Okay? So what is a sovereign? Because it says against a sovereign power. So a sovereign is a chief ruler with supreme power. A king or other ruler with limited power. So we got a whole group of people talking about, king and queen, this and that and the other, and none of them, or I ain't gonna say none of them. Excuse me, that's wrong. How many of them are truly acting like a king? Check out the video I did with King CEO, and he was talking about how sometimes you put your foot down in the family situation, right? If you're emotionally attached to whatever those restrictions are, to cause that, to cause you to want to remain in such situations, right? Check out that video. It was very deep and gives a good perspective of things. A chief ruler with supreme power, a king or other ruler with limited power. A good example, like I said, I like to put people in position. Make sure y'all tune into King CEO and Trish. I encourage them to get together, and without telling you, they're gonna have something great coming for you in the near future. I want you to pay attention to it. All right. So a chief ruler with supreme power, a king or other ruler with limited power. And speaking on that from my perspective, I always looked at it like having to put my foot down shows that I made a mistake in the selection of my teammates. Because having to put your foot down, like we were talking about in the beginning with the superstar, it's all of that's emotional to me, right? Because the reason I say that, and the reason why, because Virgos, we're really, shout out to all my Virgos out there, we're so cautious. We're so cautious that we appear suspicious. It's been noted. Okay? And see, the issue with that is to be in the mindset state of enjoying putting one's foot down. A wise person can weaponize that against you. Can weaponize that, and you'll be trapped in this endless maze because you're trying to satisfy your dopamine addiction to some sort of imaginary conquering of something, right? And that's all done to this, as a lure. Go watch the video I did with the conversation with Trish, and I discussed how anything external of yourself is a distraction. All right, let's get back to this. Because this is how it all ties together. A chief ruler with supreme power. A king or other ruler with limited power. That's what a sovereign is. Okay, so let's go back to the statement. Suits can be maintained against the sovereign power only by its permission. So permission says that it is a license to do a thing, an authority to do an act which, without such authority, would have been unlawful. So the very fact that, tying it back into what we were just talking about, the very fact that I gotta check someone means that I made an error in giving them a permission slip. And how do I refine that process? Because that's wasted energy. That's time we not making progress towards building the city, the nation, restoring power to the people, whatever, for your entertainment purposes only. So I see that as poor judgment, poor execution on my part. So it's probably plenty of people that's like, may say, oh, I told Pasha such and such. Yeah, you might have. And that's why you haven't told them anything else. You know what I'm saying? Because what they don't realize is they don't understand how invested and serious you are. And see, if you let one person pull a puppet string on you that causes you to do something that jeopardizes the whole entire mission over something stupid, that's what the enemies want. Your whole purpose in life crumbles because your emotion distracted you into something that had nothing to do with the mission. All right? So we gotta be careful with our emotions, so that we can process this information, process the environment, make the right decisions, and enact. Okay, so permission, a license to do a thing, an authority to do an act which such authority would have been unlawful. Or, excuse me, without such authority. So suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. So we got permission. And then here's ambassador. You'll hear this word come up sometimes in conversation. When it comes to sovereign. So keep in mind what you're doing when you have, let's say, an attorney. Because I'm not an attorney, but I mean, we're just going to make fun of him a little bit in this entertainment. So, in international law, a public officer, a fleecer, and maybe a typo. Okay? I'll have to look into that. But you can say a public officer or official clothed with high diplomatic powers commissioned by a sovereign prince or state to transact the international business of his government at the court of the country to which he has been sent. So, if you go back to the last video, consume that and see that, hey, EEO stuff only applies to United States citizens. Then you might start to get the feeling like you might not be or might not supposed to be a United States citizen. And if that's somehow possible and you're at court supposedly in the United States, then if you get an attorney, that's kind of like in international law, you're getting a public officer or official clothed with high diplomatic powers commissioned by, let's say, you, the sovereign prince or state, to transact the international business of your government at the court of the country to which he is sent. So when we go look at the permission, now whatever that public official says for you, because you can't speak in court being a client, right? You've sent this ambassador. See here, ambassador is the commissioner who represents one country in the seat of government of another. He is a public minister. Public minister. See, because otherwise you would be private, right? Otherwise you'd be private, right? So the ambassador is the commissioner who represents one country in the seat of government of another. Suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. Excuse me, let me turn this down. All right. So when you look at permission, right, the sovereign, well, here, let's just do this real quick. The suit is the witnesses or followers of the plaintiff. Maintained is an action or suit is, to maintain an action or suit is to commence or institute it. The term imports the existence of a cause of action. Now, once you put the ED on it, right, it actually becomes pretty interesting, because it means in pleading a technical word indispensable in an indictment for maintenance. Like my gaslighting song says, if you don't get this maintenance, must be something wrong with you. But people think it's a love song or some chick song because they don't know what the words mean, which is great. It's great for entertainment, high resale value. So anyway, let's get back to this, okay? To maintain an action or suit is to commence or institute it, and the term imports the existence of a cause of action, and that was established in Botiller versus the Milwaukee, all right, 105-8 Minnesota. Put an ED on maintain, and it has in pleading a technical word indispensable in an indictment for maintenance. For maintenance. Sometimes things need to be adjusted. Because if you're a sovereign, you're a chief ruler with supreme power, a king or other ruler with limited power. And permission would be to give, an authority to do an act which without such authority would have been unlawful. So if you send your ambassador into the other country to handle your international business and international law, that public officer clothed with high diplomatic powers, commissioned by a sovereign, prince, or state to transact the international business of his government at the court of the country to which he is sent. The ambassador is the commissioner who represents one country in the seat of government of another. Does that register now? So when we go back to this, suits can be maintained against the sovereign power only by its permission and subject to restrictions as it sees fit to impose. We basically can translate that to the witnesses or followers of the plaintiff may commence or institute the existence of a cause of action against a chief ruler with supreme power, a king or other ruler with limited power, only by its permission. The witnesses or followers of the plaintiff may commence or institute the existence of a cause of action against a chief ruler with supreme power, a king or other ruler with limited power, only by its permission. This is why they are with you, because they don't have my permission. Right? That's how you gotta look at it. That's how you gotta feel about what you got when you know who you are. Talk about stepping into your power, uncompromised, unforgiving of the truth for entertainment purposes. All right, so look, how can they get your permission? Sometimes it's because you didn't say nothing. You know what I mean? We all know. We all came from a time period. We all know someone still today talking about keep your mouth. Just don't say nothing. And I always wondered, how corny that was. Because if you really a gangster, or you really whatever you want to call yourself, I don't do titles, right? But I always could tell, even on the basketball court, I'm 300 pounds, and I could stand you up at the line at the top of the key and be like, I'm going to take you to the basket. I'm going to cut left, cut right, and I bet you can't stop me. I could tell you what I was getting ready to do. And I don't care if you were 6'8". I don't care if you were LeBron James. I'm going to do it. You can't stop me from doing it. Now, if you LeBron, you might jump on top of the backboard and block the shot at the, at the top line on the backboard. But you're going to have to do that, but you ain't going to stop me from getting there. You see what I'm saying? I could tell you what I'm ready to do. Why? Because I always felt like regardless, when you sovereign mindset, when you supreme power mindset, I can tell you what I'm ready to do. I ain't got to tell you how I'm going to do it. I ain't going to tell you that I'm going to do the hezzy and then step to the left and hit you with another hezzy and then do the Allen Iverson. I ain't got to tell you all that. I can just tell you I'm going to go left and then right and then I'm take you to the basket. Or you could tell them everything. Yeah, I'm going to do this, do that, do this, and then I'm going to do this, and then I'm going to drop the bucket on you. Just trying to keep it in perspective of courts, since we made the reference of the superstar in the beginning. If you're enjoying yourself and you're learning something, give me a thumbs up. Let me know you feeling this shit. If not, Don't be like, oh, don't send this to me in my inbox. Send it to the person you know that you kind of halfway hang around with, because you know you got some. Don't act like that. If you're not into this shit, then you know you got some people around you that you halfway borderline talking shit about how they crazy and shit, but you kind of want to be around them for this other reason over here. Okay, if that's you, then send it over to them. Don't waste your time. But don't stop the flow, just like anything else. So, you know, that was a thing. You know what I'm saying? That was a thing. You don't gotta snitch on nobody. You don't gotta be shutting other people down. Just tell them what the fuck you are, who you are, and what the fuck you get ready to do. That's how you wind up like me, having the cops, instead of the tow truck towing your shit to the impound, I've actually had police tow my shit to their parking lot with their police tow truck. Saves them some paperwork and saves me from having to pay to get my shit out the impound. Plus, it's right there when I get released, so I can hop in and drive off for everything they told me. Well, not drive off, but travel off for everything they told me I shouldn't have been. You know what I'm saying? It's a very, very efficient process. Virgos like efficiency. We don't like to waste time and bullshit. We too much studying shit to be wasting time. All right. So acquiescence is a way that you give your permission that most people don't. I ain't gonna say most people. Many people don't. Some people try to be halfway politically correct for y'all. The other half of the time, I don't give a fuck. All right. You don't say I, because man, who worried about I said I? Because if they worried about I said I instead of we, then they don't realize that I am we. So they're not ready for this anyway. They still finite. They still emotional. They looking for reasons to disassemble, because they don't realize that we all in this together. We all one. So we can't even talk quantum physics to them. They're not ready. So if they get lost on, oh, he said I, he think he did. No. If I want this for me, if I want this for I'm talking to you about I, because I have the experience I have, and I want you to be able to go talk to someone in the future saying, hey, I did this. Not I being me, but I being you at that time, because then it will be we. It'll never be we if you don't understand who you are. Wasting time with this emotional shit. All right. So, acquiescence. Acquiescence is where a person who knows that he is entitled to impeach a transaction or enforce a right neglects to do so for such a length of time that under circumstances of the case, the other party may fairly infer that he has waived or abandoned his right. So when you send your ambassador and you give permission for your ambassador to go and represent you and come back telling you you're only going to get this amount of time or this amount of fine and this many points on your license, you gave your permission through acquiescence, because what a sovereign is a chief ruler with supreme power, a king or other ruler with limited power. So acquiescence is where a person who knows that he is entitled to impeach a transaction or enforces a right neglects to do so. to the point where the other party may fairly infer that he or she has abandoned or waived his right. Suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. All this coming from immunity of the United States from suit, absent express consent. So let's take the United States out of this statement and replace it with sovereign. Immunity of the sovereign from suit, absent express consent. So let's take a look here, right? Now that we got that on the table. Go ahead, share, subscribe, comment, put your questions in the comments, and we can create a dialogue about it, and or I'll be happy to research some things if it's beyond what I know, and it'll be a great exercise for me to come back with opinions, okay? By the nature of the word. So here we go. Federal and state court plaintiffs, defendants, and witnesses. Federal and state court plaintiffs, defendants, and witnesses refers to the participants in civil courtroom trials. Now I want you to remember that word participants, because you can go to the game and you can sit in the stands and you can be entertained by the proceedings of the court, or the proceedings of the court, meaning the game, the basketball game, right? On the stage, on the TV. But if you're in the stands, you're not participating in the game. You're cheering the game. You're giving it your energy, sure, but you're not actually participating in the game. So the referee doesn't blow the whistle on you. Right? The referee doesn't blow the whistle on you. Because the rules of the game don't apply to you, because you're in the stands and not on the court. You're not on the field in football or soccer. Federal and state court plaintiffs, defendants, and witnesses. And look, imagine for a moment what it would have been like in our lives if someone in our family had sat us down with this on a tablet instead of Blue's Clues and had us memorize this stuff at that age. Imagine how different our communities would be right now. And once you appreciate how different the community would be right now, then go ahead and share this video, because that's one of the many reasons why I do it. So, federal and state court plaintiffs, defendants, and witnesses refers to the participants in civil courtroom trials. A civil trial usually means a courtroom trial in something other than a criminal case. Why would it be that? Why would that be the case? So usually, a civil trial is between two or more people or companies. It can also mean a case where a person or company is suing a federal or state government agency, or where a government agency is suing a person or a company to either obtain a money judgment or to get a court order requiring the person or company to do or stop doing something. Generally speaking, a civil trial can be thought of as one where incarceration in a jail or prison is not a possible outcome. Oh. In a civil trial, the person or company that brings the lawsuit is typically called the plaintiff or the petitioner. The person or the company who is being sued is usually called the defendant or the respondent. Remember in the last video we were talking about the respondent? Okay. These participants in the lawsuit are often referred to together as the parties to the suit. And here's where we jumped ahead a little while ago. A witness is someone who may or may not have relevant information about whatever the lawsuit is about. A witness can be a party to the lawsuit, or he or she can be someone who is not a party to the lawsuit. Often, after a lawsuit is started, but before the trial. See, look at this timing here. Often, after a lawsuit is started, but before the trial, the parties will send formal notices to people who they think might have relevant information, requiring those people to attend a formal deposition. Yeah, I spelled it wrong. I'll fix it. Or to provide the parties with documents, or both. Now, this right here is key, because it kind of sounds like if I was like some famous comedian, I would figure out some really savvy way of saying this so that you would all laugh afterwards. But it kind of sounds like when you get your little ticket or something and it says some sort of little court date on it or something, and then you go in there and they ask you all these questions, but you think you're having your trial. Like I won 3 out of 4 of my own court cases myself. So when you go in there, I'm just looking back at the little traffic court right now. They say, oh, your friends and family tell you need a driver's license. You need registration on your car. You need this, you need that. You need insurance. And they don't understand how you beat cases like that. So you get some paperwork, right, after this lawsuit about you supposedly being a defendant, right? You get that paperwork after the suit is started, but before the trial. It seems like a pretty formal notice they sent. And some people will tell you, oh, it's not you. It's not you that they want. So you got to make a special appearance and you got this, you got to do that. See, look, this might be a simple joke here. But again, after the lawsuit started, but before the trial, You get this real formal notice because they send that to people who they think might have relevant information. It's amazing how the wordplay occurs. See, they're not necessarily arguing if that's you or not. They're sending you a formal notice because they think you're one of the people who may have relevant information, and they're requiring those people, you, to attend a formal disposition. They're actually calling you regarding, and this is where you hear the term being said, because like I said, people say things and they don't tell you how they arrived there, or maybe they don't know how they arrived there. I mean, give them credit, right, for knowing what to say. But if they don't actually know why they're saying it, they just know that it works, then they can't tell you why you should know it, so you don't have the complete knowledge. All right? So they're calling on you and that's why you hear people say, oh, say I'm here regarding that matter. I am here regarding that matter. Because see, that doesn't mean that you're agreeing to be one of the parties. See, a witness is someone who may or may not have relevant information. Defendants and witnesses and plaintiffs refers to the participants in the civil courtroom trials. These participants in the lawsuit are often referred to together as the parties. A witness is someone who may or may not have relevant information. So, by being a witness doesn't mean that you're the defendant, even though the defendant might look like you on paper. I know that may be like over some people's heads, but that's good. That's okay. That's okay. For now. So a witness can be a party to the lawsuit, or he or she can be someone who is not a party to the lawsuit. Often after a lawsuit is started, but before the trial, the parties will send. See, the parties will send formal notices to people who they think might have relevant information, requiring those people to attend a formal deposition. Now, here's the bonus factor. Or to provide the parties with documents, or both. Excuse me. So you'll have people, right, that'll say, let me put it like this. Something, anything that you have supporting your claim, stating your claims, properly documented and established prior to your passing the bar, is part of your deposition. Yeah, I know. I said passing the bar. Like you hear when you think about attorneys, but I'm just making a joke about it for your entertainment. See, that is why no matter if you file documents, because you got people that's talking about, oh, I filed documents, and you got people laughing at them, right? Okay. You gonna laugh last. Don't worry about it. Because this is why no matter if you file documents with the Recorder of Deeds office or you keep a notarized copy in your briefcase until you choose to make it public with whoever, it's effective. Because what that is establishing is documentation of your claims prior to you passing the bar, which is actually a thing. We're going to get to that in a second. So, in general, a deposition is a formal, right? Proceeding is a formal proceeding where the lawyers for the parties ask the witness questions. So, and deposition and disposition, they look kind of similar. They could easily be thought to be a typo, but we'll get to that in a moment. So, in general, a deposition is a formal proceeding where the lawyers for the parties ask the witness questions. So think about it. When you go to court or you think you're going to court for your traffic ticket, when and where do they first make contact with you? Like once you get there, they're asking you questions. Hey, how do you plead? Et cetera, et cetera, et cetera, right? So the witness is usually sworn under oath to tell the truth at the start of the deposition. Such a person is commonly referred to as a deposition witness. The questions and answers are typically typed up by a court reporter into an official deposition transcript. And when I got to look into this further because, it maybe not be a big deal to some people, but I like how they use the word transcript because if you've ever had a court case and you said, hey, look, I want to get the transcripts from my case. That's what it's called, a transcripts. But if you notice, whenever we read in these real trials, not to say that the other ones aren't real, but when we read in these real trials, we got syllabus. And we got case citations. And I don't see any publication. I'm not saying they're not out there, but nothing on here says here's the transcripts. Because the transcripts would have been used in formulating the syllabus. Just a weird random thought I had, you know what I'm saying? Let's get back to this. So during the actual trial, the parties normally call one or more witnesses to take the witness stand and give sworn testimony under oath in front of the judge and the jury in cases where there is a jury. Not all trials have juries. I know some of y'all is pulling your hair out when y'all heard that statement right there. But it's entertainment. So for those that know. Okay? Such a person is commonly referred to as a trial witness. A trial witness can be a party to the lawsuit, or she can be someone who is not a party to the lawsuit. It is not unusual for a trial witness to have also been a deposition witness earlier in the same case. See, some of y'all don't even take y'all stuff to trial, and you thought you were having a trial, so maybe that was really a deposition, and then you signed something agreeing to whatever they said, huh? And then there was no need to go to trial, so it's kind of like a settlement, and then you signed it. That's some funny shit, right? Like I said, I'm not the best comedian, but this is for your entertainment. However, not all deposition witnesses are called later to be witnesses at the trial, and sometimes a trial witness was not called earlier in the case to give a deposition. All right, so if you want to be advised by an attorney, feel free to hit this Pickholes Law up. Don't even ask, okay? Pickholes Law Office. So let's look at this, right? What is court? Okay, what is court to begin with? In legislation, it's the legislative assembly, and this is where the word enact becomes powerful, right? So Parliament, it gives you here, is called in the old books a court of the king, nobility, and commons assembled, right? This meaning of the word has been retained in the titles of some deliberative bodies, such as the General Court of Massachusetts, the legislature. All right. In international law, the person and suit of the sovereign. The person and suit of the sovereign. This is why you hear, I've referenced it before, and others say they don't go to court, they live in court, right? The person and suit of the sovereign, the place where the sovereign sojourns with his regal retinue. All right? So in practice, an organ of the government belonging to the judicial department, whose function is the application of the laws to controversies brought before it and the public administration of justice. So in legislation, let's go back. In legislation, what is that? The act of giving or enacting laws. Okay? The act of giving or enacting laws. And then to make that make sense, we got to look up the word enact, which means to establish by law, to perform or effect, to decree. And to make that make sense, we need to know what perform means. So to perform is to perform an obligation or contract is to execute, fulfill, or accomplish it according to its terms. So if you are sovereign, you think you're a king, right? You have a chief ruler. You're the chief ruler, supreme power, but you get this ambassador to go represent you. And you trust them, but you don't know, you didn't give them instructions exactly on what to do because you didn't know what could be done, right? Then how are you guaranteed performance? See, if you don't know performance, If you haven't experienced performance, then how do you know if you're getting performance or not? Huh. Yeah, ask that about your relationship at dinner tonight. Okay? So, to perform an obligation or contract is to execute, fulfill, or accomplish it according to its terms. Now, dispose, so that you can see why I chose the word disposition and spelled it like that. To alienate or direct the ownership of property as disposition by will. Okay? When a case has been disposed, this means it has been closed. Specific reasons for a case being closed can include dismissal, conviction, admission of guilt, among other reasons. Once a case is officially over, it is removed from the court's docket. This simply means there are no further dates for that matter scheduled on the court's calendar. As a legal term, disposed cases can include any type of case ranging from small claims to more felony charges. Suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. Some extra bonuses for you here. Understanding the difference between dispositions for discovery and trial. So it says some states have different processes for trial dispositions and dispositions for discovery. The basic difference is that discovery dispositions aims to find out what a witness knows and how his or her testimony will appear to the court, while trial dispositions are taken because a witness may be unavailable to testify in person. So when you go and you into what you think is the courtroom, or when you go into the courtroom for entertainment purposes and they start asking you questions, it kind of sounds like the basic difference is to discovery dispositions aim to find out what a witness knows. So if they say, hey, you were driving and this, that, and the other, and you say, well, that ain't how they should be pulling out the speed trap and the radar gun. That's against my rights. Okay, now they know what you think you know, right? And they're looking to see how your testimony will appear to the court, right? They're looking to see what you think you know. And if you say, hey, look, I wasn't driving. I was traveling. Discovery dispositions aim to find out what a witness knows. And that's amazing because a lot of you don't get that you're a witness at that moment. Totally changes the dynamics. So, while trial dispositions are taken because a witness may be unavailable to testify in person, trial dispositions are taken because a witness may be unable to testify in person. So when you hear these people saying, hey, we got documentation on file at the recorder of deeds office, or I got this documentation I keep and then I send it to them when I need to tell them who I really am, right? It when done properly, it's dated at some time in the past, and it establishes your claim, certifies your claim, so to speak, in a past pretext, so that there's unequivocally no doubt in your register. Okay? So the opposing attorney may alter his line of questioning if you are unable to appear in court in person. Keep the following things in mind when you arrive to your, right? Disposition, because hold on, where was it? It said it could be done in person or with, remember the section that we were talking about, and it said in person or in documentation, right? Yeah. Here. Lawsuit. Hold on, because I want you to see this. A witness. Okay, right. Special trials, disposition. A witness. Yeah. So, right here. Often after a lawsuit is started, but before the trial, parties will send formal notices to people who they think have relevant information, requiring those people to attend a formal disposition or to provide the parties with documents, or both. See, some of y'all are going to hear documents and you're going to think statement, and you made a statement, but it was a statement about who you are that shows that you're not going to be who they think you are or want you to believe you are later on in the future when they say, hey, you were driving. See what I'm saying? So if you write that today and you have documentation that's certified to present at some point in time in the future, then you have already provided elements of your deposition to dispose of the case. So to help with your disposition. All right. As if that didn't confuse you enough, right? But look into that. So here is why I like the word dispose, because this is from North Carolina Judicial Branch website, and look at the verbiage they use here. So I received a traffic ticket. Do I have to go to court? Are there ways I can handle the case online? So it says all traffic tickets include a court date, but you may be able to dispose of your case without appearing in court. Now, of course, they didn't tell you all the ways that could be done, and I'm not going to share all the ways it could be done with you either right now. But you may be able to dispose of your case without appearing in court. And that's all the way up to the people you hear talking about, I can't go to court, I make a special appearance. Or you got the people that's talking about, hey, I sent a notice of negative appearance. Okay? So the options include waiving and and all that good stuff, right? But let's get back into this. Discovery dispositions. During the discovery phase, questions may be open-ended and probing in an effort to find out what the witness may be hiding. Some of us are single today because we could have easily been an attorney. And the world is so fake right now. So the opposing attorney will be taking notes on your responses and following up on the potential leads when he gets back to his or her office. If he uncovers evidence that conflicts with your testimony, you may have to answer additional questions, and he will likely wait until you are in front of the judge. See? Trial dispositions. Unlike discovery questioning, an attorney only has one chance to get answers from his witness or her witness. So he must prepare to ask all of his questions while the witness can be reached. For this reason, the witness is often handled as if the disposition is a live trial. The opposing attorney will usually attempt to exhaust his line of questioning, including bringing all documents and other witness testimony that he intends to use in court to the disposition. All documents. So if the attorney is going to bring all documents, you may have documents to bring as well too. Video disposition. Both the discovery and trial dispositions may be videotaped for review and use in court. So it is very important that you pay attention to your appearance and mannerisms. If your testimony is going to be videotaped, your attorney may wish to do a dry run, blah, 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 because, you know, that's them trying to get you to play up, okay? All documents. Do you have documents? Do you have documents? First of all, do you know who you are? Did you write it down? Did you get a witness to agree that it was you that wrote this down on a certain day? So that you could have documentation to provide if needed in the future. Suits can be maintained against the sovereign power only by its permission and subject to such restrictions as it sees fit to impose. So a deposition is essentially an interview where you answer questions from your lawyer as well as the opposing side's attorney. That almost sounds like you could almost think you're at court, right? For some irony there. Okay. Now let's look at this. Rule 32, using dispositions and depositions in court. Okay. In court proceedings. Using depositions in general at a hearing or trial, all or part of a deposition may be used against the party on these conditions. A, the party was present or represented at the taking of the deposition or had reasonable notice of it. It is used to the extent it would be admissible under the federal rules of evidence if the deponent were present and testifying, and the use is allowed by Rule 32A2 through 8. And then the one thing I thought you might find interesting for those that are semi in the knowledge or in the knowledge, have been entertained by this on their own, etc., 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 is number 4A. So impeachment and other party or excuse me, impeachment and other uses. Any party may use a deposition to contradict or impeach the testimony given by the deponent as a witness, or for any other purpose allowed by the federal rules of evidence. So number 3 says the deposition of a party, agent, or designee. An adverse party may use for any purpose the deposition of a party or anyone who, when deposed, was the party's officer, director, managing agent, or designee under Rule 30b-6 or 31a-4. Unavailable witness. A party may use for any purpose the deposition of a witness, whether or not a party, if the court finds A, that the witness is dead. Now, I know for some of you, you're going to be all horror and think graphic and gory things, but there's a whole nother group of y'all that's going to realize that dead could also be in the eyes of the law. Some of us are doing things and may not know why we're doing things. So it's best to have your documentation on file if you feel like you can't appear or you're unavailable because one of the parties is dead. All right. Feel free to review that at your own leisure. That's Rule 32, using depositions. So here's some basic steps in a trial. You got discovery, right? To begin preparing for trial, both sides engage in discovery. So a lot of y'all could actually do this if you really just took the time. You know, if you feel like you're unprepared, then ask for more time. Why do I say that? Because of this. In discovery, to begin preparing for trial, both sides engage in discovery. This is the formal process of exchanging information between the parties about the witnesses and evidence they'll present at trial. It's like giving the other team your playbook so they can decide if they even want to play with you or not. Some people aren't to be played with. And once they see that if they see that you're one not to be played with, they're not going to waste their resources playing with you and putting themselves at risk. You dig? Discovery enables the parties to know before the trial begins what evidence may be presented. It's designed to prevent trial by ambush, where one side doesn't learn of the other side's evidence or witness until the trial, when there's no time to obtain answering evidence. That works to your advantage. One of the most common methods of discovery is to take depositions. A deposition is an out-of-court statement given under oath by any person involved in the case. It is to be used at trial or in preparation for trial. It may be in the form of written transcript, videotape, or both. Where did you just hear that from? Videotape, transcript, discovery, trial, disposition, or both. In most states, either of the parties may take the deposition of the other party or any other witness. Both sides have the right to be present during oral depositions. Is it starting to become clear now? Because this is how they want to set the courtroom up. And they got this thing called the court well, which is what you see here in red outline. Statements made. Let's go back here. Where did it say that? Where did it say that? Critical words for memory of this entertainment. Give me one moment. Yes, a deposition is an out-of-court statement given under oath, but out-of-court statement. So when are you actually in court physically? Because this back here is spectator seating. That's the public. This is court side at the ball game, and then back here is the nosebleed sections. Yeah, the whole thing is called the arena. The whole thing is called the courtroom. But where are you actually in court, so that you will know if you have an out of court statement. So a gallery, which maybe what some of them refer to where the public sits, you can see here is, as a whole, the spectators of an event. You may also see it called where the public sits here, right, as the foyer, which is a lobby, among other things, used as a lobby or corridor or waiting room used in a hotel, theater, etc. Here's like a little generic view of the field, of the court, of the chessboard. Right? And I want to bring to your attention right here, number 10. You know, number 1 is the courtroom clerk. You got the bench. You got the witness box. You got the courtroom reporter. The well, as they call it as a whole, right? Now, you know how they get to making up their little variations in terminology, so it's hard for you to know which one's which. Here they're going to call it the empty space between the attorneys' tables. If we look here, the court, the playing field, the chessboard is the courtroom well, okay? You pick which one you want to decide there. But let's go back to this. You got the jury box. You got the respondent, remember that word, defendant table. You got the lectern, right? The podium where the attorney or party may speak, right? Give you your little stage, right? The petitioner or plaintiff. And then you got this thing called the bar, right? Number 10. Let's go back up top so I can show you on the map. Number 10. This is where the judge is up here. This is the little lectern. This is your parties, tables, jury box. This is where the public sits back here. And then number 10, right here is the bar. Now let's get back to what they call in the bar. The short half wall that separates the gallery from the attorneys. Or basically, it's the little short wall that separates the gallery from the playing field. And we already established the gallery as a whole is spectators of the event. So that's public, that's non-participant area. That's the foyer. So the well, right? If we go into here, go a little further with it, we're closing up. So the well of the courtroom is where the plaintiff, the defendant, and their attorney sit during the trial. So if the trial's not going on, does it officially become the well yet? Anything prior to the start of the trial, is that a live, active well? Can't you go down and talk to LeBron on the 3-point line if you're there before the game start during shoot around and you have the right access granted, the permission? Couldn't you be on the court area where the game is being played prior to the start of the game without interfering in the game or participating in the game itself? Is my question to you. The well of a courtroom is where the plaintiff, the defendant, and their attorneys sit during the trial. It consists of 2 seats of chairs and tables, one on the other side of the courtroom position to face the witness stand and the bench. The well also describes the empty space between the bench where the parties sit, the stage, so to speak. The stage where the attorneys state their pieces. Kind of sounds like a chess game. And then it clearly defines here the gallery is the remainder of the courtroom where people who come to watch the trial sit. It contains benches or chairs that are usually open to the public. Okay, the judge has the authority to remove anyone from the gallery who is disrupting the case. People in the gallery and the well face forward toward the front of the courtroom. The bench and witnesses stand face out toward the well and the gallery. And the jury box sits against one side of the courtroom where jurors can see the gallery, the well, and the witnesses. It's a great tennis match. Here's another site that's showing it, rhodeslaw.com. And I wanted to point out here the public seating area, okay? Because here's the rail or the bar. And they got the swinging doors, the magic swinging doors, right? So the public seating area, you will enter most courtrooms from the rear, the public door right here. The rear half of the courtroom or the room contains benches or chairs and is where the public sit when they come in. As you move from the public seating toward the front of the courtroom, you will see a railing, often with a swinging door. The railing provides the public seating area, the railing divides the public seating area from the well of the court. The well of the court is a phrase that describes the area where court proceedings are conducted. And here's what I want you to know. If you state your claim now or have already done so, this is why it adds value, right? This is on the courtroom on Wikipedia, one of your favorite sites, I know. So adjacent to the bench are the witness stand and the desk where the court clerk and court reporter sit. The courtroom is divided into 2 parts by a barrier known as the bar. And this is what it all boils down to. In law, the bar is the legal profession as an institution, which originates from the phrase passing the bar. The term is metonym For the line that separates the parts of a courtroom reserved for spectators and those reserved for participants in a trial, such as lawyers. So, if you're going to participate in a trial, it would behoove you to have already established your disposition prior to your passing the bar. And that is why your documentation and your discoveries are so valuable. Take your time and prepare. Pasha Paro. If you learned something today, if you found it helpful, by all means, support the channel. That could be a share, it could be a like, it could be commenting. Ask questions, get engaged with other people in the comments, in your community. Pull this up on your TV, on YouTube, and watch it with the family and talk about it afterwards. You can always donate to the channel via CashApp or PayPal. And with that, I thank you for tuning. YNet 7.